Okay, so I'll just, I have 20 minutes, so I'll be very brief on REACH law. Then I'll go through the UK REACH basics. Just tell you what you need to do if you're a UK-based company or EU-based company and you want to comply with the UK REACH regulation. Then I said, look at some of the opportunities and threats and conclude with that, and then I have a few questions at the end to the audience. So REACH law, what we do, we provide chemical regulatory compliance services globally, and we focus on REACH-like regulations. So like the UK REACH regulation to come once there's a Brexit. And then, for example, in Turkey, there's a similar regulation that we have in the EU, and of course, EU REACH. We're based in Helsinki. We have offices, except in Helsinki, of course, we have in Brussels, London, in New Delhi, where we service the Indian market, but also lately in Moscow, and of course in London and Istanbul. And why we have locations in these places is so that we can provide services locally, like only representative services. So these are the focus of our services. So the UK REACH regulation, come Brexit, will also be within our scope of services, and that will be the focus today. And we have a stand in the other room, so if you want to come and talk about details, then please do come. So we specialize in chemical regulatory support for companies placing chemicals on different markets in different jurisdictions. So the UK REACH basics, just a few slides on this. The UK REACH regulation will enter into force upon Brexit according to the Withdrawal Act. And based on current information, it is end of this month, but who knows? There's been some rumors about postponement till next summer, but then Johnson will be lying dead in a ditch anyway, so we'll see. Yeah. So, as mentioned, I will just assume that in this presentation that there's a no-deal exit whenever that happens. Of course, these same requirements also end up entering into force upon if there's a deal exit after the transitional period. But in this presentation, just let's assume there's a no-deal exit, which is fairly likely, I would say, looking at the latest news from this morning, for example. So the UK REACH regulation, it's actually a copy-paste of the EU REACH regulation. There are, of course, subtle changes, differences like the jurisdiction and the different bodies or entities mentioned in the regulation, as well as the so-called transitional arrangements. Other than that, it's essentially a copy-paste. So if you know EU REACH, you will know UK REACH also. And it's actually been around already for half a year, more than that, and it's been amended actually 2 times already. So we'll see if it'll be amended even more times before UK's exit. So the UK REACH regulation, as mentioned, will retain the same requirements as the EU REACH regulation, which means essentially that if you're placing or manufacturing a new substance on the UK market at 1 ton or more, whether it's a new innovative chemical or just existing substance, you will have to register it before placing it on the UK market. There are transitional arrangements which I will talk about, which give some leeway upon exit. Then there are authorization requirements, the same as in the EU REACH regulation. So the existing Annex 14 defining the substances subject to authorization will be carried over to the UK REACH regulation, as well as restrictions and so forth. The authority, the ECHA, so to speak, in the UK will be the HSE, so the Health and Safety Executive. They will accept all the different registration dossiers and authorization applications and so forth. And these will be submitted to the HSE through a UK REACH IT system, which has been now in development for a year or so, and it's in its final stages, I hear. So, as mentioned, there are transitional measures in this regulation for the purpose of that there would not be disruptions in business. So for example, if you are a UK-based company and you have a EU REACH registration, you're a holder of a EU REACH registration, this will be carried over, grandfathered to the UK system. If you are an authorization holder, the same goes, they will be carried over to the UK REACH system. But also if you are importing substances that are registered in the EU 27 countries and you are importing these into the UK and downstream using them currently, then there is a transitional scheme of 2 years before you actually have to register these substances. Up until this time, you will actually be allowed to just use them without a proper registration. So it makes it possible to continue the business, chemical business, in the UK upon a no-deal Brexit. So these are the transitional measures, and I think these presentations will be shared, so I think you can have a look at these in more detail later. So if you are a UK-held EU registrant, that means that you are based in the UK, but you have a EU REACH registration for your substance. These will be grandfathered into the UK REACH regulation. You have to, within 120 days, notify the the HSE that you are a holder of these registrations, so that they will be the transitional measures, the grandfathering will be applied to you. Then if you are an importer of existing EU REACH, EU 27 registered substances, then you have to, within 180 days, do a so-called downstream user import notification. This makes it possible for you to continue the use of this substance until the 2-year deadline. And the 2-year deadline comes from here that you have to, does the laser work? Yeah. It means that within 2 years upon exit, you will have to register your substance, either as a lead registrant, if there is no one else taking the lead for your substance, or as a co-registrant, meaning you're joining into a joint submission where a lead registrant then submits the lead dossier. Then for authorizations, I will not go through authorizations more than what is on this slide, but if you are a holder of a EU REACH authorization in the UK, you will also be grandfathered. This authorization will be grandfathered into the UK REACH system. You just have to notify, again, the HSE within 60 days of exit. And the same goes if you are a downstream user of an authorized substance, you have to notify within 60 days upon exit that you are covered by an existing authorization, whether it be in the UK or whether it be in the EU, the authorization holder, that is. Restrictions will also be carried over to the UK REACH regulation as such. So what does this mean for you if you want to comply with the UK REACH regulation? If you are a UK-based manufacturer or importer or an only representative, and you currently hold an EU REACH registration, what you do is you will have to open up a UK REACH IT account. You have to validate, that is, notify your existing registration to the HSE within 120 days. Once you do that, you get a UK REACH registration number. After that, provide the full registration dossier within 2 years after the UK leaving the EU. And the trick here is actually that when the UK exits the EU, it might be that you no longer have access to the same data, legal access to the same data that you did for EU REACH purposes. So this has to be negotiated again, and you will have to likely pay for this data again. The good thing is with these grandfathered substances is that you do not have to pay an HSE registration fee, because it has already been paid to the ECHA before. However, if you are a UK-based downstream user, distributor, that means that you are currently receiving EU REACH registered substances, EU 27 registered substances to the UK. What you have to do, you have to open up a REACH IT account. You have to do the downstream user import notification within 180 days of exit. then you can choose your UK REACH compliance strategy, basically. It means that either you seek that the manufacturer formulator, the non-UK manufacturer formulator, appoints an OR, an only representative in the UK, or then you can yourself as an importer go ahead and prepare the registration dossier, again submit it to the agency within 2 years. However, as this would be seen as a new substance, not grandfathered, it means that this will be, you will have to pay the HSE registration fee again. And the registration fees are essentially the same in the UK as they are for EU, albeit the UK market is much smaller than the whole of EU. So then the last complex slide is where you are a non-UK manufacturer or formulator, meaning that you can appoint an OR in the UK for UK REACH purposes. In this case, you need to choose again your strategy. Will you just have your customers in the UK take care of UK REACH, or will you appoint an OR? If you appoint an OR in the UK, such as Reachlaw, for example, the only representative then would have to open a UK REACH IT account. They will also do a downstream user import notification within 180 days. On top of that, they will have to submit an inquiry for the substance. After the inquiry, they go ahead and prepare the registration dossier, co or lead, and submit it again within 2 years. And I can tell you from experience from EU REACH, 2 years is a short time for developing a lead dossier, albeit the data is already available. But negotiating access to these studies and so forth, it takes time. So again, if, as this would be a new registration, HSE registration fees apply. So if you appoint an OR as a non-UK company, as a non-UK manufacturer formulator, all your customers in the UK would just be seen as downstream users. They would not have to do their own registrations according to the UK REACH regulation. And the same applies in the UK as we have within the EU, is the one substance, one registration principle. It means that you form joint submissions together to register the substances jointly. And this is still under debate how this happens in practice. It can be quite complicated. For UK companies who want to access the EU upon exit, of course, they can, if they're a manufacturer formulator, they can appoint an only representative in the EU. If they're distributors, they cannot. They can only go back to their supplier, ask, can you appoint an OR in the EU, or maybe they have already, or then just have the EU importers take care of EU compliance, EU REACH compliance, that is. So if you are innovating new substances, new molecules, just be aware that you have to comply with these chemical regulations in the UK also. So before you start innovating, just make a case, check, is it worth it from a regulatory point of view? How long does it take to become compliant with these regulations, with the UK REACH regulation? And if it's feasible, then you can go ahead. But my message here is that you have to incorporate also regulatory compliance into the innovation process. I'm sure something that everyone does nowadays, but go back 10 years, R&D did their own thing and didn't care about regulations. All right, opportunities, threats, just a few more minutes. So of course, opportunities is that if you make the effort to become UK REACH compliant, then of course you may have an edge to your competitors. And of course, highly speculative at this point, but in the longer run, it might be that the requirements according to the UK REACH regulation will become less stringent than the one in the EU, albeit they start off from the same level, but maybe in the long run, like less restrictions, less authorization requirements and so forth, and maybe more exemptions, meaning that you can manufacture articles with substances of very, very high concern in the UK and ship the articles to the EU compared to now doing it in China and shipping them to the Europe from there. So UK is a bit closer than China. Who knows? Maybe, but that might be an opportunity. it was easier to list the threats. Of course, again, more regulations to comply with. A big threat, of course, adding to the already complex regulatory scheme. On top of that, of course, if you are an EU-based company, EU27-based company, there are a lot of registrations, 740 of those that are only registered in the UK. Those will, upon Brexit, upon UK's exit from the EU, those will be void in the EU. So if you are currently relying on those substances, you will be in deep trouble. You will not have, your substances will not be registered in the EU come Brexit. So also, if they are originating from the UK, it might be that then the UK manufacturer formulator does not want to appoint an OR. Maybe the volume isn't enough to justify the additional costs and so forth. I will just skip a few of these because time is of the essence here. At the end of the day, it might be that the importers have to then comply with these requirements in the EU for EU REACH purposes. Then again, for UK-based companies, the same goes. I think the biggest threat for UK-based companies is that the UK market is much smaller than the EU. So it might be for the chemical companies do not see that as interesting enough to make the effort to become UK REACH compliant. And of course, chemical traders in the EU, of course, they will have the same problem as the Swiss traders had with the EU REACH regulation. They cannot appoint their only representative themselves. So they will have to have the importers register or then ask for the actual manufacturer or formulator of the mixtures to then appoint the only representative. Okay, at the end of the day, of course, it might be that the UK REACH regulation will become even more stringent than the EU version. I don't think that will happen, but who knows? That might be a threat. Okay, so conclusions. So the EU REACH, the UK REACH regulation will have the same context, the same requirements as the EU REACH equivalent. There will be transitional arrangements for registered chemicals, for existing authorizations, and so forth. Non-UK manufacturers and formulators can appoint an UK-only representative to take care of UK REACH obligations. R&D chemical products can also, you can also apply for a so-called PPOR notification in the UK if you are manufacturing new substances that are under development. So that is the same requirement as we have in the EU. So it's good to know that you can have that also. But the supply chain risks, that's something, an obsolescence of, let's say, not availability of substances post-Brexit is something that is a big question at the moment. For bulk chemicals, it's not a problem, but maybe for the more specialty ones, it is. And just to wrap up, going a few minutes over time, few questions to the audience. I don't expect there will be any answers to these questions. But what do you think will happen with the chemical supply chains upon Brexit? And what will be the impact on innovating new chemicals in the EU or in the UK? I do not have any answers to these. I'm looking for you to provide some comments, please.
Just a comment from the supply chain problem. I mean, it's going to end up being higher costs for everybody
Yes.
to deal with that.
Yes.
It's added, and in my opinion, unnecessary complexity.
Yes.
But the chemical innovation, I don't think that's going to slow it down.
Yeah. As said, I only identify opportunities for consultants with Brexit.
There you go. Yeah.
Any other thoughts? Yeah, please.
Let's start with two very simple questions for you. Do you have any? I'm pleased to see that Euclid is still the data format. Do you have any information what happens when ECHA is going to Euclid 7? Will this be synchronized? That's one question. Second nasty question is, ECHA has implemented the technical completeness check in the system, but there is also the manual completeness check. Do you have any information whether DEFRA is going to do a manual check also? And what happens if there are inconsistencies between ECHA and UK?
First of all, I think both questions are equally nasty, because I do not have answers to those. I think, speaking from experience, talking with the HSE, they never have a clear answer. They say, I'll come back, and then they come back like in 3 months when they've thought about it. So I'm sure they have not thought about, for example, the Euclid 7 system, or the manual or automated checks. They say that the systems will be the same for checking dossiers, so I assume there will be some sort of manual process also, manual checks, but most of them will be automated. That's my guess, and I'm sure they will implement Euclid 7 also. But those are just speculations at the time. So, any other questions?
Fredrik, thank you very much.